Welcome to the Compliance Council on Command webinar series. Today's topic is the error resolution and information request requirements in Regulation X. The error resolution and information request requirements are under the RESPA servicing rules. You have the truth in lending servicing rules that are really scattered throughout Regulation Z, your arm adjustment notices, periodic statements, payoff statement requests, etc. And your RESPA servicing rules are all in new sections of Reg X, the implementing regulation of RESPA. That's in 1024. That 35 references the subsection of Reg X within which the error resolution procedures are. So you'll find this out in 1024.35 of Regulation X. In sum, at a high level, these are new error resolution procedures for closed-end mortgage loans. You're already used to error resolution procedures on credit cards and on electronic funds transfers under Reg E. Now these are new detailed procedures for mortgage error resolution notices that you get. The general timing is you have to respond within 5 business days of that written notice and acknowledge receipt, and generally investigate and give a notice that the error has been corrected or that no error has been found within 30 business days. We'll go into a bit more detail of the process that you go through here in a moment. But what is an error, first of all? Obviously, it's any failure related to servicing of the loan. The last bullet is really the important one. It's anything relating to failing to accept a payment, failing to pay a charge, imposing a fee or charge where you shouldn't have, inaccurate payoff statement requests, any errors regarding foreclosure or the notice of foreclosure. What it's not going to include is any error that's outside of the realm of servicing. So by a certain error related to underwriting of the loan or anything that occurred prior to consummation, that's not going to trigger this regulation, because that's not a servicing error. Let's go through the error resolution process in a bit more detail and highlight some items that can be confusing. So the first step of the process is you receive that written error notice. Note that word written. This regulation is only triggered when you receive a written error notice. If you choose to take oral notices, it's not going to trigger the timing in this regulation. It has to be in writing. Now, in writing can be in paper form, the traditional letter, or you can provide an online or email mechanism by which written error notices can be submitted electronically. If you do choose to use electronic notices, you still have to give borrowers the option to send one in paper, but you can take them electronically and trigger this regulation if you choose. Once you receive that error notice, the first step is to determine whether it's a validly asserted notice or not. Does it contain the borrower's name, account number, or other information by which you can identify the account, and information that reasonably identifies the error, information that you need to be able to investigate. If it doesn't contain that information, then you respond within 5 days and indicate that more information is needed. If you do have a validly asserted error, and you move on to the next step in the process. The next step is determining if the error is duplicative, overbroad, or untimely. This really gives you an out if you get the same error over and over again from a borrower, if you get an error that is just so overbroad that you really can't even identify what the error is. They assert 100 things within some large document, and you really can't even identify what they're getting at. Or if it's an untimely error, it's a year or later after you've transferred the loan or the loan is closed or the loan has been paid off. You're not going to have to respond and investigate and respond to duplicative, overbroad, or untimely errors. The difficulty with this step that I see often is that overbroad definition. That's very subjective. What is overbroad? Duplicative is easy enough. Is it the same as one that's already been asserted? Then it's duplicative. Overbroad can be difficult. And the real difficulty to me lies in that you can have, and it states this in the commentary, you can have a validly asserted error within overbroad errors. So if you get one of those, I'm sure you've all received them, a document from a borrower that looks like it's some type of legal pleading, has a lot of wherefores and heretofores in there to make it sound very official. Looks like something they probably printed online from some bogus website and sent out to anyone they have an account with. You get one of those, it could have 20 or 30 assertions or complaints, and all of them except one could be overbroad and ridiculous, where you can't even identify what they're talking about. But if one of them states, my March 1st payment wasn't credited properly in full, that could be a validly asserted error within that document. And it can be difficult to determine if they have an overbroad error that you can essentially pump back to the borrower, or if you have a validly asserted one. So that's an area where you're going to want to be sure at the bank to have procedures where somebody is reviewing these to see and make that determination of whether it's an overbroad error. The next step, the fourth step, is the acknowledgement of receipt. If you've determined that it's duplicative, overbroad, or untimely, within 5 days, respond and notify the borrower of that fact. If it's a validly asserted error and they've provided the information, it's not untimely, overbroad, or duplicative, then you just acknowledge receipt within 5 days. So you send them a very brief letter that says, we've received this on this date, then notify them of the timing within which you'll respond. Then you move on to the investigation time period. First, before you even get there, determine, can this error be resolved within 30 days? That's the general default timing within which you have to investigate and respond to an error. You can extend it out to 45 days, however, if you need more time. If you do need more time, up to 45 days, you need to send another notice to the borrower notifying them that more time is necessary and the reason why you need more time. After the 30 or 45 days has run, now you're at the time period where you send the borrower the notice of the resolution of that error. If you found an error and you corrected it, notify them of that. If you investigated the error and found that there was in fact no error, you notify them of that and the reasons for that finding. Information requests are in 1024.36. This provides, very similar to the error resolution procedures you need to follow when you get a written request for information from the borrower relating to servicing of the loan. You have to acknowledge receipt. You have to provide that information out generally within 30 days. The process here for information requests is very similar to error resolution. You can extend it out to 45 days if you want, the same 5-day, 30-day, or possible 45-day timing. One key difference here is there are some additional exceptions in the information request area. In addition to duplicative, untimely, and overbroad, which we discussed, in the information request area, you can also not respond, not provide the requested information if they request something that's confidential, proprietary, or privileged, if it's irrelevant, or if it's unduly burdensome. Confidential, proprietary examples of that would be if you have attorney-client privilege documents. If they're requesting documents that are not relating to the servicing of their loan, but that are more in the aggregate. So maybe statistics on the servicing of all your loans or financial information of your bank. That could be confidential, proprietary. It could also be irrelevant. It could be either of those, really. Unduly burdensome, similar to overbroad, can be a bit nebulous, a bit difficult to define. If somebody requests all of the documents pertaining to their loan and it's going to be thousands of pages, perhaps that would be unduly burdensome. Again, I'd encourage you to have some procedure where the determination of whether a request for information or a notice of error is overbroad or confidential or unduly burdensome, that gets kicked up to somebody who makes that determination. So you have consistency within the process that you can document and show to your examiners. So that's the general process for error resolution information requests. Acknowledge receipt within 5 days, respond within 30 or 45, depending on if you've extended it. There are some extensions to that. One is payoff statements. A payoff statement is very similar to an information request, but it's handled by its own regulation in Regulation Z. And you have to respond to those payoff statements no later than 7 days of the request. And you have to, generally within 5 days is a reasonable time period. So it's not the same as an information request. You don't get 30 days. It's got to be no later than 7. An error related to a payoff statement is also not the same as a normal error. Because payoff statements generally are requested when there's a refinance or some other transaction happening, you need to respond to errors regarding a payoff statement on that same timing that you would provide the payoff statement out. So generally within 5 days, no later than 7 days. An error regarding a foreclosure sale. If you have a foreclosure sale scheduled and say a borrower asserts an error and says that should never be scheduled, I'm in the middle of a loss mitigation agreement that I'm performing under, this foreclosure shouldn't be scheduled. You can take 30 days on that still if the error is asserted 30 days prior to foreclosure. But if they're closer, if they're within 30 days of that foreclosure date, you need to respond prior to the foreclosure. The exception to that is if you're 7 days or fewer prior to that foreclosure sale, then you're exempted from the requirement to respond prior to the foreclosure, but you're still expected to make some good faith effort to investigate it to the extent that you can. Another exception to the general timing is information requests on who the owner or assignee of the loan is. If you get a request for the name or address of the owner or assignee of the loan, you respond within 10 days after receipt as opposed to the 30 days. At your option, you can designate an exclusive address where you will receive notices of error and information requests. You don't have to. So here's what happens if you don't. If you don't designate an exclusive address, then your borrowers can send their error notices or information requests to any bank location, and it's going to trigger this timing. You'll have to acknowledge receipt within 5 days, investigate it, and respond generally within 30. For some smaller banks, that might not be a problem. You might have a small enough number of branches and have strong enough communications between your branches that wherever the borrower sends it, you're going to be able to respond within the time frames. If that's the case, then you may not need to designate an exclusive address. If you're a larger bank with a lot of branches, or if you have concerns that you'll be able to acknowledge receipt within 5 days if it's sent to some faraway branch, then you might want to consider designating an exclusive address. What happens when you designate that address, if you tell me, the borrower, that I have to send my error notices or information requests to 123 XYZ Street, if I send it to another location, this regulation is not triggered. It's only triggered if I send it to that designated exclusive address. So how do you designate that address? You have to provide a separate written notice of the address. That notice can go along with a statement or go along with some other document, but it has to be a separate written notice. If you're required to provide periodic statements under 1026.41 in Reg Z, that's if you're not a small servicer, then you have to provide that address on your mortgage periodic statements. If you are a small servicer, you don't have to provide periodic statements, so you're not required to designate the exclusive address on there. However, if you're a small servicer and you're choosing to provide periodic statements, whether they're compliant with 1026.41 or not, as a best practice, I'd encourage you to designate that exclusive address on the statement if you have that option and ability. You have to designate this address on any website that you maintain in connection with servicing of the loan. If I can go out on your website and look at my payments, look at my credits, that's a website pertaining to the servicing of the loan. You have to designate that address there. You also have to designate it on the required disclosures that you provide to delinquent borrowers, early intervention notices and loss mitigation option notices. This is another area where you small servicers that service less than 5,000 mortgage loans will be exempt from. You're not required to provide those notices, but if you're not a small servicer, you need to provide this address on those notices. For you large servicers, or non-small servicers, I should say, there's an additional requirement that sometimes gets lost because it's not actually in 1024.35 or 36, where the error resolution information request regulations are. It's in the general servicing policy and procedures section of Reg X. And it requires you to inform the borrowers of your written error resolution and information request procedures. This is similar to the credit card error resolution procedures or Reg E procedures that you're required to provide either annually or on every statement. The difference here is they don't give you any model language. So the credit card error resolution procedures, there's model language. You just ensure that you send it out annually, or there's a short form you can put on the back of the statement. Here, the regulation states that you have to inform the borrowers of your written mortgage error resolution information request procedures, but it doesn't give you any guidance as to what that looks like, and it doesn't give you any model language to use. So I think if you model it based off of the Reg E and the credit card error and provide that general level of detail, but obviously customize it to the mortgage rules, I think you'll be complying with this. Small servicers, you're not required to do this. This is only for non-small servicers. So before we conclude today, let me go out of this PowerPoint presentation and open up a document that I'd be glad to send to anybody if you think it would be useful for you. So I've put together a document that is really a summary of the error resolution information request procedures in a bank procedure format. So, of course, I wouldn't suggest that any of you take a template procedure and just adopt it without customizing it to your bank. Procedures are very customized from bank to bank, or they should be anyway. But this at least provides all the information that would potentially need to be addressed in your procedures. So I'll go through in great detail notice of exclusive address, the process, what if there's information missing, what if it's duplicative, what if it's overbroad or unduly burdensome, what are the categories, what's the content that's required in your responses. So if this document would be useful to you, just shoot me an email or give me a call. My contact information is on the first slide of this presentation, and I'd be glad to send it along to you. So that really concludes this error resolution information request presentation. Again, let me know if you need that document, and thank you all for listening.